Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain the eviction laws in South Dakota and outline some simple steps that landlords can take to initiate an eviction. We're eForms, the largest online database of fillable legal forms. In this video, we'll talk about what the eviction process looks like, how South Dakota laws affect evictions, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video as well to find a link to a fillable eviction notice that can be used in South Dakota. First, what is an eviction? Eviction is the process of legally removing a tenant. Even if a tenant has failed to pay rent, it's illegal for a landlord to change locks on a property or physically remove a tenant from that property. If the tenant refuses to leave after violating the terms of a lease agreement, a landlord must seek an eviction from the court. Eviction is different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended. There's no need to involve a court in this process. If a tenant in South Dakota fails to pay rent or breaches the terms of a lease agreement in some other way, the landlord can issue an eviction notice. This is a document that orders the tenant to either fix a specified problem within a specified number of days or face being evicted. There are several versions of this notice. Let's talk about each one. As of 2024, if the landlord gives a notice to pay or move out, the landlord can start eviction 1 day after the rent is due. Without the notice, the landlord must wait 3 days before starting eviction. In short, the landlord can either 1, give notice and take action immediately, or 2, not give notice and wait 3 days to take action. If the tenant breaches the lease in some other way, then the landlord can send a notice to quit for non-compliance. This is a notice that must assign a specific number of days. Within this period, the tenant must either rectify the problem or vacate the property. South Dakota law says the window must count as a reasonable time frame in which to fix the issue. The 30-day notice to quit is a little bit different because it doesn't require a lease violation to be effective. This one can be used by either the landlord or the tenant to let the other party know that a month-to-month lease agreement will not be renewed at the end of 30 days. A copy of the appropriate notice to quit should be served on the tenant. Under state law, the notice should be served in a way that allows for proof of service to be obtained. An example is hiring a process server to serve the notice. If the server attempts to serve the document twice and the tenant is not home, then at least 6 hours after the second attempt, the notice can be posted in an obvious place on the property or delivered to another person residing there. State law also says that after 2 attempts have been made to locate the tenant in person, then the notice can be sent via first-class mail. If the tenant does not respond to the notice to quit by resolving the identified issue within the number of days allotted, the landlord is legally entitled to bring an eviction proceeding against the tenant. This can be done in any circuit court or magistrate court within the county where the property is located. The first step in filing an eviction action is to file a form called a verified complaint. A copy of this should be served on the tenant along with a summons to appear in court. A sheriff, process server, or constable should serve these papers on the tenant. A minimum of 2 attempts must be made to locate the tenant in person according to South Dakota law. Those attempts should be a week apart and both should be within 30 days. If on the second attempt the tenant is still not located, then the summons may be posted in an obvious place on the property, delivered to another person residing there, or sent via first-class mail. Both parties should attend the hearing, which could occur as soon as 4 days after the summons is served on the tenant. If the court rules in the landlord's favor, the judge will hand down a judgment, which returns the possession of the property back to the landlord. If the tenant still refuses to move out, the landlord can obtain an execution for possession from the court. This may only be served in the daytime as per South Dakota law. It essentially authorizes the sheriff to forcibly remove the tenant and the tenant's possessions from the property. From eviction notices to court documents, eForms has everything you need to get eviction proceedings going in South Dakota. Access it all at the link below. Thanks for watching and don't forget to subscribe for more.